Hey, Ted.
Good morning, everybody.
Morning, everybody.
Good morning.
Can you hear me?
Yes,
Morning, Your
I
Honor.
can.
Yes.
Good morning, Your Honor.
Good morning. I think everybody's here.
I believe so.
Just going to wait a minute, make sure that we are live, but I think so. And Mr. Court Reporter, are we ready to go on the record? You're muted, so I can't hear you. There you go. Are you there?
Can you hear me now?
Yes, I can hear you now. Thank you.
I'm here. I'm sorry.
That's okay. Are we ready to go on the record?
We're ready.
Okay, thank you. Good morning, everybody. Today is January 5th, 2023. My name is Christine Burke. I'm a public utility law judge with the Maryland Public Service Commission. We're here today for case number 9688, which is the application for the Southern Maryland Electric Cooperative, Inc. for authority to revise its rates and charges. We're here today for a pre-hearing conference. Can I have the appearances of counsel, please, for the company?
Yes, Your Honor. My name is Mark A. McDougall, and I'll be representing Southern Maryland Electric Cooperative in this case.
Good morning. Thank you.
Good morning, Your Honor. My name is Theodore F. as in Frank Duver, and I am with the law firm Bracewell, and I also will be representing the Southern Maryland Electric Cooperative in this case. I just want to also just make it known to Your Honor that yesterday we had filed a motion for admission pro hoc vice. I want to clear up, there was a little bit of confusion because apparently there were two filings made. And I just want to, for the record, give the correct mail log number. The correct filing is 300719, and the other filing can be disregarded.
Okay, thank you. I did see that. Great. And for the Office of People's Counsel.
Good morning, Your Honor. Jacob Auslander, Assistant People's Counsel with the Maryland Office of People's Counsel. And with me on the call today is Juliana Bell, the Deputy People's Counsel with the Maryland Office of People's Counsel.
Good morning. Thank you. And for staff counsel?
Good morning, Your Honor. James Greger on behalf of staff. I would also like to enter the appearance of Kenneth Albert and Peter Wolfson. Thank you.
Thank you. Good morning. Could we start with the certificates of publication, Mr. McDougall?
Excuse
Before
me.
we do that,
Yes.
Your Honor.
I'm sorry, Miss Lee. I apologize.
Yes, no problem.
You know what?
Yes,
Also, yes, I did see your intervene. I overlooked that. I apologize.
it's no problem at all.
Yes, so for the
This is
record,
Angelina Lee.
state your appearance. Thank you.
Yes, this is Angelina Lee from the Office of Counsel for Navy Facilities Engineering Command. I'm here on behalf of the Navy, representing the federal executive agencies in Southern Maryland area. And with me, I believe on the call are Ms. Kay DeBooty and Mr. Larry Allen, who are also with the NAVFAC's Public Utilities Office.
Good morning. Thank you.
Thank you.
If we could now go to the certificates of publication, Mr. McNichol.
Thank you, Your Honor. By way of mail log number 300724, SMECO filed its certificates of publication in accordance with your directive on January 4th, 2023. The certificates of publication show that a display advertisement was published on December 16th and December 23rd in Southern Maryland News, which consists of the Maryland Independent, Charles County, the Calvert Recorder in Calvert County, and the Enterprise in St. Mary's County. In addition, we published the same notices in the Enquirer Gazette on December 15th and December 22nd, and that's Prince George's County. We also issued notices of notices of this pre-hearing conference by way of social media and on our website as directed.
Thank you. Is there any objection to admitting the certificates of publication into the record?
No objection.
Objection, Your Honor.
None by the company.
Thank you.
No.
That will be marked and entered into the record as Company's Exhibit 1. Next, the petition to intervene that was filed by the Department of the Navy. I did see that was filed yesterday under mail log 300723 by Ms. Lee. Is there any objection to the Department of the Navy's petition to intervene in the case?
No objection by SMECO.
No objection by the Maryland Office of People's Counsel, Your Honor.
No objection from staff, Your Honor.
Thank you.
Your Honor,
Hearing
if I may,
Yes.
the petition to intervene also included a motion for appearance of counsel based on reasons by federal law. I have since learned that Maryland Supreme Court has already issued an order in 1983, which allows for special appearance of counsel of federal agencies to represent the agencies in front of the commission. So if I may, I would just to state for the record my appearance of counsel.
Yes, and I became aware of that as well yesterday. So
you.
your petition to intervene is granted, as well as your motion for appearance of counsel.
Thank you.
Thank you. I did receive a copy of a proposed procedural schedule that was presented by, I'm assuming, all the parties as a joint schedule. Can someone go over the basic dates of that for me?
Oh, I would like to go over those, but before I do so, this was a proposal, a joint proposal by SMECO staff and the Office of People's Counsel. At the time that I had submitted it to you, Your Honor, the Department of the Navy had not yet filed its motion to intervene. And so the Department of the Navy is not one of the joint proponents of that schedule. Since that time, the Department of the Navy circulated an alternative proposal to the parties, and that was circulated this morning. What I'd like to do is go over the joint proposal that SMECO staff and OPC submitted to you, and then we can go on to other matters as the Navy would like. The proposal that the joint parties have put before you have direct/reply testimony of staff, OPC, and interveners on February 10, 2023, rebuttal testimony on February 24, 2023, surrebuttal testimony on March 9, 2023. Sometime between the rebuttal testimony and the hearing, which I'll speak to next, we're going to have a public hearing, a public evening hearing in Southern Maryland. And we don't have particular dates for that, but we thought we could look to your schedule as well as the other parties as, to set that later. The hearing we're proposing to be held on March 15, 2023 through March 17, 2023, if we need 3 days. In the past, SMECO's cases have not needed 3 days, but we thought we would reserve them just in case. Initial briefs then would be filed on March 31, 2023, reply briefs April 7, 2023. And then we were thinking that a target date for the proposed order would be almost a month later at May 5th, 2023. Because there's a statutory time constraint in this case, the parties would agree to a shortened appeal period of that proposed order if any appeals are noted. They would have to be filed with the memorandum of appeal on May 17, 2023. Reply memoranda on appeal May 29, 2023. And then, of course, the commission would have about a month if they needed to issue an order in this case, because the suspension period would end near the end of June. And if I did my lawyer math correctly, and I'm not sure I exactly did, I think the suspension period would end on June 29, 2023. There are a couple of actually more than just a couple of discovery issues that the parties discussed. We agreed that if this procedural schedule holds up and the judge issues an order approving it, SMECO would use its best efforts to respond to data requests propounded after today within 8 working days rather than the typical 10 working days that are in effect. Discovery procedures would be modified to reflect a 4 business day turnaround or best efforts to respond to the first round of data requests propounded between the filing of rebuttal and surrebuttal testimony, and then a 2-day turnaround to respond to follow-up data requests to those responses. The parties would use their best efforts to respond to data requests before the start of the evidentiary hearing following the filing of surrebuttal, and in no event shall discovery be served after the witness whose testimony is the subject of the data request is scheduled to testify. And the last issue on discovery is that during the discovery process, objections to data requests are to be propounded in the, objections to data requests that are propounded in the 8 working day turnaround period shall be within 3 working days of receipt. Objections to data requests propounded in the 4-day turnaround period shall be within 2 days of receipt, and objections to data requests propounded in the 2 working day turnaround period shall be within 1 day of receipt. With all of that, the parties would like to have available to them the ability to put on live rejoinder to surrebuttal testimony at the evidentiary hearing. And finally, the parties would request Your Honor to extend the suspension of rates for an additional 30 days beyond the initial 150-day suspension to accommodate the procedural schedule that I just outlined.
Thank you, Mr. McDougall. Ms. Lee, do you have a copy of what was proposed by the parties?
I do, Your Honor. I will.
Do you want to go through date by date, which ones were acceptable to
Yes.
you?
Yes, I can. First of all, I do want to apologize to everybody that I wasn't able to participate in the conversation prior so we could come with a unified proposed schedule. However, given the fact that the Navy had some difficulty in assigning the proper counsel to this matter, we would like some additional time to file its direct testimony. And that is really what we are, the change that we're proposing is really focused on the moving the timeline to allow for additional time to file its direct testimony. So the proposed dates that I have would allow direct testimony to be filed on February 24th, 23, with the rebuttal testimony being due on March 8th, 23. As with the proposed schedule, the evening public hearing, we would leave that up to the judge's discretion, Your Honor's discretion, and sub-rebuttal testimony would then be due on March 15th, 23. And with that, the anticipated hearing date will be March 20th through March 22nd. And subsequently, the initial briefs following the hearing will be due on April 4th, 23, with the replies due on April 11th, 23. And I understand that Your Honor would need sufficient time to issue its order. We would propose that order be due on May 8th timeframe, which would allow for the appeals period to proceed as currently proposed. There will be no impact to the other dates that are proposed on May and June timeframe.
Well, the main issue I have is with the evidentiary hearing dates that you're proposing. I'm not available the following week on March the 20th. The other dates that were proposed are acceptable. So I'm inclined to keep the dates that were already proposed by the parties with the evidentiary hearings taking place the 15th through the 17th. And I understand that there may be some delay or some crunch time for the Department of the Navy. However, given the sort of compounded schedule as it is, inclined to keep the dates that were already proposed.
Would it be acceptable for the parties to allow additional week for filing the direct testimony, to move that date from the 10th to 17th, and allow the rest of the schedule to continue as proposed?
Do any of the parties have an objection to that?
Your Honor, this is Ted Duver for SMECO. SMECO really could not agree to a movement. There has been a lot of discussion among SMECO staff and OPC to arrive at the dates that were originally proposed, to Your Honor. And SMECO also does recognize sort of making certain that the Navy has adequate time to be able to prepare its direct case. But one of the things that we just want to make known, as Your Honor already knows, is that the rebuttal testimony in this case is a very, very important opportunity for the company to be able to address what we expect to be a high volume of testimony from all of the parties, in particular from staff and OPC. And it is that first jump, and to take away an entire week's worth of time and compress the discovery time period that SMECO would have available to it to take discovery of staff and OPC, and then to put together adequate record on which Your Honor and the Commission can then make a reasoned decision, that the company could not agree to, because it really, we believe, would prejudice us. One of the things that we would note is also that I don't even mean to speak for the Navy, but the expectation would be also that the issues that are important to the Navy are more discrete. There is a rate schedule that applies directly to the Navy. It will most likely be a cost of service rate design type issue that the Navy will be dealing with. We note that the Navy has had the filing since December 1st. They were served since that time at the same exact time as all of the parties in this case, even though the Navy had not obviously intervened at that point, but by agreement between SMECO and the Navy, SMECO has always agreed to provide the Navy at the first possible instance any rate adjustment filings, and that was done. And in fact, the Navy has been in contact with the company as early as earlier this month over this filing. The final point that I would just like to make is that there's also like the history in the past regarding the filings. That SMECO has filed 4 rate cases since 2010 in the last 12 years. Of those 4, in 3 of them, and they are case number 9456 on August 1st, 2017, that was filed, and 9234 that was filed on June 17th, 2010, and 9106, which was filed on May 1st, 2007. The Navy also intervened in those cases in order to protect its own interest, but in the record, it reveals that the Navy had at some point after analyzing the case decided not to participate and not to file direct testimony. There was an intervening case in 2015 where there was no intervention on the part of the Navy. And so the SMECO's position would be that the current schedule as proposed by staff, OPC, and the company is one that provides adequate time to everyone involved, even the Navy. And like I said, I don't want to speak for the Navy, and I recognize the difficulties they had in getting counsel put in place. But this really would prejudice, we believe, all of the other parties, even if it is just that one date. In particular, I think SMECO would be prejudiced by having a full week taken off for their opportunity to take discovery and file direct testimony.
Thank you, Mr. Duver. Does anybody else want to be heard?
Your Honor, James Greger from staff. So just to echo some of the concerns outlined by SMECO, any compression of the rebuttal or sur-rebuttal time periods would kind of limit the discovery opportunities from OPC and staff as well. Given the complexity of this case and the fact that in many rate cases, rebuttal testimony significantly changes the details that were filed in the original application, that discovery opportunity is critical for staff to conduct its analysis. So staff would also oppose any change to the procedural schedule that was outlined by the OPC and staff in this case. Thank you.
Thank you, Mr. Greger. OPC?
Yes, thank you, Your Honor. It almost feels a little bit like deja vu because we had a lot of these same discussions earlier this week when we were trying to hammer out the agreement between the parties. And the time frame is compressed, but I think that's the nature of the beast because of the statutory timeline and the number of things that need to be done before that final order is issued. So we support the joint procedural schedule that was submitted to Your Honor yesterday, and we'd ask you to approve it.
Okay, thank you. Ms. Lee, do you have any response?
Yes, Your Honor. I would just like to state that the opportunity to examine the records and obtain information through discovery is crucial to the Department of Navy's understanding of the case and its evaluation of the case. And the fact that it has not intervened or filed its testimony in the past does not change the fact that it may be necessary for this particular case. However, given the fact that that there is a compressed time schedule that everybody must adhere to, and there's a statutory deadline that we're trying to meet. I understand the difficulties that are involved in changing the schedule, and I understand everybody's concerns. However, I would like the commission's consideration as to our proposed schedule as well.
Okay, thank you, Ms. Lee. I tend to agree with the parties as it is, and I'm going to adopt the procedural schedule as proposed by the other parties and note that the Navy is on a small, shortened time frame. However, notice was provided, and you have had an opportunity to know, despite the difficulty assigning the case. I'd like to talk a little bit about the public hearing dates. I was going to propose first, I'd like a feel for the parties' positions as to whether it should be a virtual hearing or an in-person hearing. I'd like to hear from the company.
SMECO is indifferent as to whether it would be a virtual hearing or an in-person hearing. We had our annual meeting in August of this year, and we had it as an in-person meeting. And we were able to set up the chairs for the attendees in a way to keep them appropriately distanced. I know things have changed since August. They are always changing, and they probably change between now and
February.
in February or March or whenever. But we're amenable to making it a virtual meeting if Your Honor would like. So I'll leave it up to you how you would like to do that.
Thank you. Does OPC have any position?
No, Your Honor, we would not have a position on whether the public hearing would be in person or virtual.
Staff?
No, Your Honor, we don't have a position on this matter.
Okay. I was going to propose dates of February 23rd or February the 28th. Is there a preference among the parties for those two dates?
Your Honor, if I could check my calendar, give me a moment, please.
Your Honor, the Navy would like to request February 28th.
The 20th would work for OPC as well, Your Honor.
Staff has no objection to February 28th, Your Honor.
I think the 28th would be fine for SMECO as well, Your Honor.
And as of now, I'm inclined to make it an in-person hearing, with the caveat that if things change in any other direction. We've been doing hearings live at the commission for several months now without any difficulty. So I would prefer it to be an in-person hearing, although I would note as well that, circumstances and things have been changing on a regular basis. So we'll get to that when the time comes. Okay. Is there any other issue or any other concern from the parties that has not been addressed?
Not from SMECO standpoint, Your Honor.
Thank you. And OPC?
No, Your Honor. We think that everything that we wanted to be covered has been covered in this hearing so far.
Okay, thank you. And staff?
No, nothing further from staff, Your Honor.
And Ms. Lee for the Navy?
None from my end, Your Honor.
Thank you. Okay, well, I believe that concludes today's hearing. I will be issuing a procedural schedule shortly. I appreciate everybody's participation today, and thank you.
Thank you, Your Honor.
Mr. Court Reporter, we can go off the record. Thank you.
Your Honor.
Thank you, Your Honor.
Thanks.